Okay, here we go. Unit 11, Real Estate Contracts, just over halfway through the course. A brief summary of this unit. Just remember, contracts in general, they are an agreement between two or more parties, supported by a consideration. It's a voluntary agreement or promise between legally competent parties. Both sides have got to make a promise to do something for the other. And it must include some form of legal consideration. What both sides are doing has to be legal. And the contract also defines each of the parties' legal obligations and rights. What they have to do, what they don't have to do, how they can get out of the contract, and so forth. And certain contracts have to be in writing to be enforceable. So enforceable in courts when certain conditions are met. We talk about that a bit later. As a licensee, you are prepared to you are allowed to prepare certain types of contracts. Agents can prepare approved leases of 1 year or less. Remember that 1 year or less for leases. And licensees are allowed to assist buyers and sellers in the preparation of 4 types of contracts. There's a listing agreement. This is the deal between the seller and an agent and a broker. Buyer brokerage agreement, when you have an arrangement with a buyer. Sale and purchase contract, when you write an offer. And also an option contract, though we advise it's best done by an attorney. I'll just show you quick examples of a listing contract here. And this is the sort of thing you see. It's 4 pages, and it basically lays down the seller and the broker and the term at the time of the contract or the listing agreement and property address and so forth. I beg your pardon. And by a brokerage agreement, a simple 3-page piece of paper that allows you to work with a buyer, and the buyer promises that you'll get a commission if they do end up buying a home. And sale and purchase contract is when we write an offer to a seller's agent on a particular property. It is 12 pages long, quite extensive, and we'll go through that a little bit later on. And the option contract, I don't have one of those. Central elements of a contract. Both parties have got to be competent. Could be voidable by a minor if a minor enters into a contract. Offer and acceptance. You have to have someone who's offering, you have to have someone who's accepting. We call this a meeting of the minds, when they get together and go through every aspect of the contract. The person presenting the offer is the offeror, and the person receiving the offer is the offeree. It's got to be for legal purpose on both sides. And the consideration, who is giving what for what, can be valuable consideration, which is basically money or anything that can be turned into money, and good consideration, which doesn't have a monetary value but has another value. It's like, for instance, love and affection. But we do say the Statute of Frauds. Statute of Frauds says, listen, if you're going to be writing out contracts or anything that's to do with conveyancing of real property, then it's got to be in writing if you want it to be enforceable in court. Doesn't mean that the contract isn't valid if it's not in writing. It just means that the judge is going to have a hard time looking at it. And the ones we talk about are purchase and sale contracts, option contracts, deeds and mortgages. And once again, here's this 1 year deal. Lease agreements for more than 1 year, listing agreements for more than 1 year. There's also a statute of limitations, which means you can't be held to a contract forever and ever. If it's a written contract, it's 5 years. If it's an oral contract, it's 4 years. We also call oral contracts parole or parole contracts. So when we look at a real estate contract, we have to have competent parties. We have to have an offer and acceptance. We have to have a legal purpose. It has to be in writing if you want it to be enforceable. Oral is okay, but it's hard to prove in court. And it has to contain valuable or good consideration. If a contract is badly written, then it may be a void contract. It doesn't meet all the requirements needed for a valid contract, therefore has no legal effect. In fact, it's not a contract at all. If there is something in the contract that allows one of the parties or the other party to pull out of it, it may be a voidable contract. a contract in which one party may cause the contract to be voided. Unenforceable one means that we're not going to be able to take it to a court, and it may be because it is in writing, or maybe it's not in writing rather, or maybe because it's run out of time after the 5 years or the 4 years. We have a formal contract which is historically written with a seal in the old days, but basically if it's on a formal piece of paper, then that's a formal contract. If it's an oral contract, then it's an informal one. On a contract where both parties have to perform, that's a bilateral contract. If only one party has to perform, but the other has the option to perform or not to perform, then that is a unilateral contract. An express contract is when we have sat down and we have declared either orally in writing or either orally or in writing that we have a contract. That's an express one, but an implied one is not necessarily we talked about it, but our actions and the way we behave does indicate that we have got a contract implied. An executory contract is one which has been signed and accepted, but the promises haven't been fulfilled yet. It's like a pending contract. Executed means both parties have performed according to the contract, and therefore it's not a contract anymore because the deal's been done. An executed contract has been performed. Also, we do talk about documents being signed or wanting to be signed. We call these executed documents when all the signatures and initials are present that are required. We have a contract negotiation. The person who makes the offer is the offeror. The person who receives it is the offeree. And when there's a counter offer, then the original offeree now becomes the offeror and sends the counter offer over, but it does kill the original offer and substitutes the counter offer in its place. Here's a quick example with some figures. Here's Ken on the right. This is the example out of the book. And he is offering $34,000 to Rebecca for a lot of land. He sends the contract, the offer over, and Ken is the offeror and Rebecca is the offeree. Maybe Rebecca rejects it and says, no, I don't want to accept your $34,000, but what we're going to do is I'm going to counter offer $35,500. So now Rebecca is the offeror, and Ken, when he receives the offer, is going to be the offeree. Now Ken may accept this offer, in which case, when that offer is actually communicated back to Rebecca, then the two of them have a contract. Let's supposing Rebecca sent the offer over, but then before it reached Ken, the counter offer rather, she decided to cancel it. She can do that as long as it hasn't reached Ken. So remember that an offer only becomes a contract when the acceptance is actually communicated back. And whilst any of these offers or counter offers are in transit, they can be cancelled as long as the cancellation gets to the other side before the actual offer or counter offer does. Okay, ways an offer is terminated. It can be withdrawn from the offeror. The offeror can go insane. Or, of course, the offeree could go insane. Lapse of time. An offer usually has a time expiration date on it, and therefore it could just expire. Or if one of the parties dies. And we've got a counteroffer. When a counteroffer is issued, then that kills the original offer. Or if the offer is accepted, then that offer now becomes a contract. The offer can be rejected, or, of course, what we're wanting to buy, the property, can be destroyed, and therefore there's no basis of the contract. When we have a contract, how can we terminate a contract? Well, by performing both sides, that ceases now to be a contract because it's an executed contract and the deal has been done. Or both parties can mutually agree to renounce the or rescind the contract. Or impossibility of performance. Let's supposing the property falls down a sinkhole. Then obviously I can't go ahead and buy a house that doesn't exist anymore. And the contract. Once again, because of the Statute of Frauds, 5 or 4 years, lapse of time will cease the contract. And of course there's a breach. In other words, if one of the parties refuses to perform as promised in the contract, then that is a breach, and then we go into a different set of circumstances. Remedies for breach. You can go to court and order the judge, or the judge will order one of the non-performing party to perform specifically according to the contract. If it's the buyer that defaults, the seller may ask for the earnest money as liquidated damages. Liquidated damages means I can quickly get what is in the escrow account as cash damages to me. Rescission. Go back to court, and the judge may say, listen, you're both as bad as one another. I'm telling you both to cancel the contract and start again. The buyer will get any earnest money back, and they're back to their original position. And then compensatory damages. Maybe the liquidated damages aren't enough for the seller, for instance, and therefore the seller may sue the buyer for more damages for the trouble that he has gone to with regards to the contract. It's a civil suit for money damages suffered because of a breach. So remember those: specific performance, liquidated damages, rescission, compensatory damages. A party on a contract may, with permission of the other side, assign their rights and duties to another person. Especially on a purchase contract, the buyer may decide not to buy it himself, but wants somebody else to buy it instead. As long as the seller agrees, then that can be done. The person who has the original contract is the assignor, and then when they sign it over to someone else, that someone else is the assignee. Novation occurs when a new party now becomes obligated to the contract. The original party is released. So novation is a bit we add into the contract. I'll show you that in class when we actually do allow the original buyer, in the case of a purchase contract, to assign it to somebody else. Assignment and novation. Assignment occurs when one party transfers rights and duties to another person. We see this on a purchase contract. The buyer may want to assign the buyer's rights and duties to somebody else and substitute as a buyer. That person would be the assignor, and the person receiving the new rights and duties, the new buyer, would be the assignee. If we want to relieve the original buyer of the obligations to the contract, then we have to have a novation clause or agreement in the contract to release that person and make the new buyer totally responsible. Listing contracts. Agreement between an owner and a broker. Sales associate's authority is derived from their broker. Remember, all listing contracts or all contracts are necessarily between the customer or client and the broker, not the agent. But a listing contract may be written, oral, or implied. But we have to have a definite expiration date, description of the property, listing price and terms, broker's compensation, and the signature of all the owners. And in Florida, we have to get a copy of any listing contract to the sellers within 24 hours. And an automatic renewal clause is prohibited. There's a $200 fine if you do put that in there. There are different types of listings we can have. An open listing is more than one broker is allowed to list the property. And when that one broker sells the property, they will get paid a commission. But if the owner still sells the property themselves, then none of the brokers get the commission. We have an exclusive agency listing where only one broker is allowed to list a property, but the owner is still allowed to sell it themselves as a for sale by owner. And if they do that, no commission will be due. And then we have an exclusive right of sale listing, which is the most preferred by agencies, because that means no matter who or how the property sells, if it does sell, that listing broker will get the commission. We could have a net listing. A net listing can be open, exclusive agency, or exclusive right of sale. And this is basically where the broker retains any excess proceeds or in excess of the seller's net. The seller comes to the broker and says, hey, I want $120,000 for my property. Anything you can get more for it, you can keep. Well, can be a bit dodgy because the broker may recognize that the home is worth a lot more than the normal commission, and he could end up defrauding the seller out of a lot of money. So what we have to do is work backwards on this. Normally when we list a house, we say we're going to be listing it for $155,000, and we're going to take off our 6% commission, which gives us $145,700. And then we have to take off our closing costs, which is $3,700. Then we get $142,000. Now, in the case of a net listing, we know that want the $142,000, so we have to work backwards. In this particular case, we get the $142,000. We add in the $3,700, which gives us the total net, including the closing costs, and that represents 94% of the listing price. So we get to $145,700, we divide it by 0.94 or divide it by 94%, and we come back to the original listing price of $155,000, and that's what we would recommend to the seller. We have a multiple listing service. So the multiple listing service is, if you're a member of the association, you are a member of the MLS, and that allows all brokers to put their properties on, so all the other agents in the MLS and in fact around the world can see your property when it's syndicated out. But one of the deals about putting your listing on the MLS is that you promise to share with other brokers the commission that you earn from it. So as listing information may be entered into the MLS's listings with the owner's permission, and then participants in the service, even from other brokerages, can show your listed property, and if the buyer buys, receive a part of the commission. We do have a buyer brokerage agreement. This is when I'm being retained by a buyer to look for homes and show homes. I want to make sure that at the end of the day I do get a required amount for the deal, whether it's a fee or a commission. So I would get the buyer to sign an agreement with the broker that when I work for that buyer I will get paid a certain amount. It'll have a starting date and an ending date. It will indicate what sort of properties and area we're looking at, and also the broker's obligations and the buyer's obligations, the compensation, including possibly a monthly retainer, a protection period. In other words, after this agreement has expired, I don't want you going and buying a home that I've already showed you, because I may be entitled to a commission. And if you want to terminate it early, there may be penalties you have to pay. But it is an authorized brokerage relationship, and we will determine what type of relationship we will have, single agent or transaction broker. Broker's compensation, not the agent. The commission is negotiable between the broker and the seller, either a percentage or a fee. But it's based on whether I find a willing, able, and ready, willing, and able purchaser who meets the terms of the contract, or the listing agreement rather, to buy the home from the seller. And if the seller accepts, I get paid a commission. If the seller doesn't accept, then I still get paid a commission because I did my side of the bargain. But the listing agreement may say effect a sale. In that case, not only is it good enough to find a ready, willing, and able buyer to purchase a property, but we've got to get it all the way through to closing. Then I will get paid a commission. For a broker to be paid a commission from another broker, they have to have a current license, must be employed through a listing or buyer broker agreement, and they must show that they are the procuring cause that started the sale. Here's an example of a listing agreement where the seller agrees what type of commission is paid and how much. And in this particular case, it says even if it doesn't close, if we find you a ready, willing, and able buyer, then I will still get paid. We do have option contracts. This is a unilateral contract where the optionor has obligations. That is the seller of the house, but the optionee, a potential buyer, has a right to buy. If the buyer decides they want to buy, then the seller has to sell, but the optionee, the buyer, doesn't have to buy. And usually for this option, the buyer or the potential buyer will pay extra money, maybe on the lease or something like that. All the usual information is required, and options are assignable, and you do have to have a license to receive any commissions from this. And if you are actually a listing agent or you're interested in obtaining the option yourself, then you have to divest yourself from the transaction altogether and act as purely a potential buyer. And you have to make sure there's substantial valuable consideration paid for the option. We do have sale and purchase contracts. It's a 12-page form at least, where we have the vendor, which is the seller, and the vendee, which is the buyer. Bilateral contract. That means both parties have to perform, and it has to be in writing and signed under the Statute of Frauds. And you'll have the name of the seller and the buyer, the vendor and the vendee, legal description and consideration and purchase price, and also financing or cash terms, what the buyer is prepared to do with regards to financing, and the type of deed that they're expecting. And we want to see some title evidence to make sure that the title is free and clear. And then the expenses and prorations that have to be paid. We cover that at a later chapter. And if there's any personal, not real property included, and also the date and the time, and sometimes the place of the closing, and when when the buyer will actually be allowed to move into the property. We do need all the signatures of the owners, if it's a married couple, or any of the owners that are on the deed. If the property is homesteaded but only deeded to one person, we still need both signatures. Nobody can sign on behalf of anybody else any of the contracts unless they actually have a power of attorney from the person. The power of attorney makes them attorney in fact, and it can be general or specific to the house or the document. And if you are using a power of attorney to authorize you to sign a document, that document has to be acknowledged. That means witnessed and notarized and recorded if it's to do with the purchase of a house. We do have obligations to tell the seller, be it for sale by owner or a regular seller, that they have to disclose in writing or orally to any potential buyers anything that's wrong with the home that affects the value, that we cannot see any material defects. This is a Johnson versus Davis Supreme Court. The fact that the seller is selling it as is does not circumvent this duty to disclose any defects in the house. I've just added in there, never lived in, does not circumvent this duty to disclose. We do have to issue a statement on the sales contract about radon gas. This is purely information that radon gas may be dangerous, so check on it if you want. There's no obligation for the buyer or the seller to test or fix. Purely a disclosure. There's also a lead-based paint form for houses built before 1978. And in the lead-based paint disclosure, the seller declares if they've got any reports or not have any reports on any lead-based paint contamination in their building. And also we make sure that the buyer gets an EPA lead pamphlet, and the buyers are allowed 10 days inspection to cancel the contract. And if you are a contractor mitigating any lead paint, then you have to have an 8-hour course to be qualified. Here's the lead pamphlet which you have to give to the buyer. You also have to give an energy efficient rating brochure to any potential buyers. This is a copy of that. This allows them to possibly get a cheaper mortgage on a well insulated high-end applianced house. We have to put in an owners association disclosure summary if the home is under a homeowners association, and this basically gives them a 3-day right to rescind the contract if they don't like the terms of the HOA and the fees. We also have to put a property tax disclosure on the sale contract indicating that The taxes we see now may not be the same as the taxes you'll pay next year because they may be increased. If you're selling a home which you've had some building code violations, then you can sell it to a new buyer, but you've got to pass over the proceedings and the pleadings and the notices of those violations. And then it'll be up to the buyer to comply with the code. And then the seller must forward the name and address of the new owner to the code enforcement agency within 5 days. Some homes are in a community development district which will incur separate fees yearly or quarterly or monthly, and therefore we do have to give them a CDD disclosure indicating what community district they're a part of and how much it's going to cost them. Be very, very careful not to misrepresent, conceal, or omit to say any relevant statements, material facts to buyers or sellers. You can get into trouble. That's misrepresentation. If the buyers or sellers act upon your information and end up financially out of pocket, then you can be charged with fraud and you'll be made to pay damages by a court of law and possibly discipline from DPPR. Also, the restrictions regarding we cannot sell parts of properties covered under one mortgage. We can't offer to repurchase at a later date a property when we sell it unless the plan is state approved. We can't offer discounts or homes with lotteries or games of chance or puzzles or any challenging games. Always be honest. Behave like you would want someone to behave towards you. Do not betray that trust, because just one small act of mistrust can destroy years and years of reputation, not only of you, but of your broker and possibly the company. Okay, so that is the end of Unit 11. Hope you enjoyed it, and I'll see you on the next unit.